In 1973, the Supreme Court ruled in Roe v. Wade that the 14th Amendment's right to privacy extended to a woman's decision to have an abortion. They created the trimester framework. In the first trimester, the right was absolute. In the second, the state could regulate to protect maternal health. In the third, viability, the state could ban abortion to protect potential life, as long as there was an exception for the life and health of the mother. This ruling struck down abortion bans in 46 states. It nationalized the issue. In 1992, the court modified Roe and Planned Parenthood v. Casey. They threw out the trimesters and focused on viability, the point where the fetus can survive outside the womb around 24 weeks. They also introduced the undue burden standard. States could pass restrictions, like 24-hour waiting periods or parental consent laws, as long as they didn't place a substantial obstacle in the path of a woman seeking an abortion. This allowed red states to chip away at access while keeping the core right technically intact. It led to the TRAP laws, targeted regulation of abortion providers, that closed many clinics. Then came June 2022. In Dobbs v. Jackson Women's Health Organization, the Supreme Court overturned both Roe and Casey. Justice Alito wrote that the Constitution does not confer a right to abortion. He argued that because abortion is not deeply rooted in the nation's history and tradition, it is not a fundamental right. This decision did not ban abortion nationwide. It returned the authority to the states. It essentially said, the voters in Mississippi can decide for Mississippi, and the voters in New York can decide for New York. The result was immediate fragmentation. Trigger bans, laws passed in anticipation of Roe falling, went into effect in over a dozen states, banning abortion almost totally. We now have a map where abortion is illegal across most of the South and Midwest, and protected in the West and Northeast. This creates abortion deserts. Patients in Texas must travel hundreds of miles to New Mexico or Kansas. This disproportionately affects poor women who cannot afford the travel. It is a realization of the reproductive justice critique. The wealthy still have choice. The poor have forced birth. This created a legal collision with EMTALA. As we discussed, EMTALA requires hospitals to stabilize emergencies. If a woman comes to the ER miscarrying and septic, the stabilizing treatment is often an abortion, uterine evacuation. Federal guidance says doctors must perform it. But state laws in places like Idaho say doctors cannot perform it unless the woman is literally about to die. This leaves doctors in a double bind: perform the abortion and go to state prison, or refuse and face federal fines and malpractice. The courts are currently battling over which law reigns supreme. Almost all bans have an exception for the life of the mother, but the statutory language is vague. How close to death must she be? 50% risk? 90%? Imminent? Doctors, fearing felony charges and loss of license, are waiting until patients are crashing, septic, hemorrhaging before they act. They are practicing defensive medicine in the worst sense. We are seeing cases where women are sent home to wait until they get sicker. This is the chilling effect of criminal law on clinical judgment. The new frontier is medication abortion. The combination of mifepristone and misoprostol accounts for over half of U.S. abortions. It can be managed via telehealth and mailed. This makes physical clinics less relevant. The legal battle is now over whether states can ban the mailing of FDA-approved drugs. Anti-abortion groups are invoking the Comstock Act and 1873 anti-obscenity law to try to ban the mailing of abortion pills nationwide. If successful, this would bypass state protections. Another battleground is travel. Justice Kavanaugh wrote in a concurring opinion that states cannot ban women from traveling to get an abortion, citing the constitutional right to travel. However, some states, like Idaho, have passed abortion trafficking laws, making it illegal to help a minor travel for an abortion without parental consent. Major employers, like Amazon and Disney, are offering to pay travel costs for employees. This sets up a showdown between red states and woke corporations. Finally, we must look at fetal personhood. Some states are moving to define a fertilized egg as a person with full rights. This has massive implications beyond abortion. It threatens IVF. In 2024, the Alabama Supreme Court ruled that frozen embryos are children, causing clinics to halt IVF treatments for fear of liability if an embryo was destroyed. It also threatens contraception methods like the IUD, which some define as abortifacients. If a fetus is a person, then the entire landscape of reproductive medicine becomes a minefield of homicide law. To conclude, Lesson 3. We are in a period of profound legal chaos. For the first time in 50 years, the definition of healthcare depends entirely on your zip code. Clinical judgment is being subordinated to criminal statutes. As policy analysts, you must navigate this. You must understand that providing standard obstetric care in Texas now carries risks that it does not carry in California. In the next lesson, we will look at another population whose bodies have been controlled by the state, the mentally ill. We will discuss deinstitutionalization,